Welcome, everyone. Thank you for joining us today for our final presentation of our three-part webinar series, Mastering GLP-1 Compounding, Regulatory Insights, Business Strategies, Reimbursement, Telehealth, and Legal Considerations. My name is Martha Rumore. I'm a senior counsel at Frier Levitt. I head Frier Levitt's intellectual property team. I'm a registered patent attorney at the United States Patent and Trademark Office. I'm also a PharmD JD with over 20 years of experience representing pharmacy clients on various regulatory compliance issues, from FDA matters to State Board of Pharmacy matters and PBM issues. Previously, I served as a Director of Drug Regulatory Affairs in the pharmaceutical industry and at the director level in several hospital pharmacies in New York. And most importantly, I have compounding experience for many years as an oncology pharmacist, so I speak the language. I'm pleased to be joined by my colleague, Matthew Modafferi. Today, we're going to explore the current regulatory landscape for compounding pharmacies and specifically the intellectual property challenges for 503A compounding, lawsuits by brand manufacturers, and strategies for risk mitigation. The materials and information provided in this presentation are for information purposes only and not for the purposes of providing legal advice. This is our disclaimer. The information contained in this presentation is a brief overview and should not be construed as legal advice or exhaustive coverage of the topics. Matt, could you please introduce yourself?
Sure. Welcome, everyone. My name is Matt Modafferi. I'm a partner here at Frier Levitt. I lead a litigation team in the Healthcare and Life Sciences Litigation Department. My clients include 503A compounding pharmacies, biologics labs, oncology practices, self-funded plan sponsors. It kind of varies, but still under the umbrella of healthcare and life sciences. I also represent clients in various government investigations, whether it's DEA or OIG investigations. With respect to today's presentation, I have two active matters involving Novo Nordisk and had represented clients that had dealings with Eli Lilly as well. Before joining Frier Levitt, I was an assistant U.S. attorney in the civil division of the U.S. Attorney's Office in the Eastern District of New York. And I'm also an adjunct professor at Brooklyn Law School where I teach litigation skills, which is probably why I'm in charge of the PowerPoint presentation. But with that, I just wanted to share a little bit about the firm, about Frier Levitt. For those of you who are clients, great, you know us. For those who are not clients and are not quite familiar with us, we are a healthcare boutique law firm. We have about 50 lawyers, not including support staff. We basically, I like to describe the firm as you know, yes, we're focused on healthcare, but we have experts in the various fields and subcomponents. And what I mean by that is we have clinician attorneys. Martha is an example of one. Martha is an attorney, but she's also a pharmacist. We have other attorney pharmacists on staff. We also have former podiatrists, hospital administrators, clinicians, medical billing coders on staff. To break down Frier Levitt a bit further, we have a healthcare team. Our healthcare team represents hospitals, large physician practices, medical staffs, etc. We have a regulatory team that can help walk you through the various healthcare rules, regulations, and requirements. And then our pharmacy and life sciences team, we represent thousands of pharmacies across the country. And sort of the topics that we represent our clients in range from board of pharmacy, PBM audits, government investigations, PBM litigation, and general litigation, just as a broad overview. That's not an exhaustive list, but just a very broad overview. And with that, I will turn it back over to Martha.
Thank you, Matt. Before we start, a few housekeeping items. The webinar is going to be recorded. You'll receive a link to view the webinar on demand. And during the presentation, you can send us questions using the Q&A tab on your screen. The questions are private and visible only to the presenters. We'll answer as many questions as we can at the end of the presentation. And if you'd like us to answer your questions at a later date, our emails and phone numbers are included on the screen, so feel free to contact us anytime. Next slide, please. GLP compounding landscape. So the response from the pharmacy community regarding this three-part GLP compounding series has been tremendous. And as I mentioned in part one of the series, there's a great deal of buzz in the pharmacy community about compounding, especially the weight loss products, particularly semaglutide compounding, and now actually the whole class of the GLP-1 agonists. The legal skirmishes regarding compounding have been around for decades. They've intensified and they've increased. There's been allegations of intellectual property infringement, unfair competition, and those are the two squares that we're going to talk about in this third part, the litigation and the IP advertising issues. And as Matt mentioned, at the firm, we have a multitude of legal and regulatory issues that our clients present us with on a daily basis that involve the challenges faced by pharmacy compounders. Next slide, please. So this is really an overview of the current landscape for semaglutide and tirzepatide compounding. The compounding for semaglutide, it's limited to the base only, and everybody knows that by now, not the sodium salt or the acetate. FDA has explicitly made that clear. The next requirement is that it cannot be essentially a copy. And since both semaglutide and tirzepatide are on the FDA shortage list, that is an exception. The 506E FDA shortage list does not list the branded oral semaglutide tablets, only the injected. So one has to consider whether that indicates that the constrained supply of the branded drug may be more related to the availability of the sterile syringe pen device in which the drug is given. And we're going to talk a little bit about the patents for that pen device shortly. FDA guidance talks about essentially a copy. There is a specific guidance on that and what is not essentially a copy. Things like plus or minus 10% strength difference, different routes, additional ingredients being compounded, for example, cyanocobalamin, pyridoxine, included. The next requirement is for a certificate of analysis, and knowing what to look for on that document is crucial. The API manufacturer has to be FDA registered, and the vetting of the API suppliers to make sure they're registered is critical. Going forward to mitigate risks, some of the best practices would be to develop a policy and procedure to vet API manufacturers, checking the FDA website, and even going one step further to look to see if there's been any warning letters or recalls. Another best practice would be to, make sure you request a copy of the original manufacturer certificate of analysis. The boards of pharmacy want the original, not a transcribed copy not a transcribed copy from the U.S. importers. So they really are looking for the original. Obtaining a statement from the distributor that the API is pharmaceutical grade. If using research grade, that's not subject to the same strict manufacturing practices as pharmaceutical grade API. So the compounding must be with pharmaceutical grade product. In order for the 503A compounders to continue compounding once the drugs get removed from the FDA shortage list, and that is going to happen eventually. The question is how soon. We do know that Novo Nordisk just purchased Catalent. It's a contract manufacturer in New Jersey. They purchased that for $16.5 billion. They also purchased 3 manufacturing sites from Novo Holdings for $11 billion. So they are ramping up production, and no one knows how quickly that's going to occur. Medical necessity would need to be shown once the drugs are taken off of that shortage list, and then the pharmacies could not be compounding essentially a copy, because if the drug is commercially available, what would be the need to compound the same exact thing, essentially a copy? So then you're going to need to have medical necessity. And that is defined as producing a significant difference for the patient. It has to be documented on each prescription, and it has to be explicit. So if you're compounding, for example, a sublingual version, a medical necessity of the patient doesn't like injections or something like that would not be adequate. Any kind of blanket statement pre-printed on the bottom of a prescription is not going to be adequate. Also, like the prescriptions themselves, the medical necessity has to be patient specific. It has to actually be on the prescription. If it's not on the prescription, then the pharmacist does need to call the prescriber and clarify the medical necessity. And the notation has to be kept by the pharmacy for at least 3 years. Next slide, please. So some of the claims, and my colleague Matt's going to go into the actual claims and some, that we're dealing with all the time. But this slide shows some of the claims that the GLP-1 litigation involves. The manufacturers are increasingly dismayed by the compounding, and that compounding has been on the rise for the past 2 to 3 decades. And the result is that the manufacturers are claiming unfair competition. At the same time as this is occurring, there's something like 300 drugs on the shortage list, on the FDA shortage list. The U.S. is experiencing the worst drug shortages in over a decade, and many of these drugs are life-saving therapies like antibiotics or chemotherapy drugs for patients with cancer. So nobody can deny the important role to alleviate shortages by 503A pharmacy compounding. But perhaps the most controversial drugs on the shortage list now are these GLP-1 agonists. Last Thursday, you had Eli Lilly state that it was suing 6 more entities, including medical spas and wellness centers, for selling products claiming to be tirzepatide. And the lawsuits are based, on several things. One, that they are advertising the compounded versions are FDA approved, and that there's an increase or an appearance of versions that are actually, counterfeit. And counterfeiting is a subset of trademark infringement. A defendant really can't be found guilty of counterfeiting under the Lanham Act without first being liable for trademark infringement. And they have to show that the defendant, intentionally used the plaintiff's trademark, knowing that it was on a counterfeit product. Also, last week, you had the WHO released an alert regarding 3 fake batches of semaglutide that were detected in the US, the UK, and Brazil. And that was, those batches were detected in October, December 2023. In May, you had Novo Nordisk filed 9 additional lawsuits against medical spas, weight loss clinics, and pharmacies with claims like unlawful marketing and sales. So far, they've filed 21 lawsuits. Some have been settled, and my colleague will go into some of the settlement issues. One of the consistent allegations that you see that on the slide is trademark infringement. They also include state common law, unfair competition laws, and every state has laws regarding unfair competition in the form of trademark infringement, exploiting goodwill and damaging the reputation of a brand's mark. For example, the state of Georgia has the Uniform Deceptive Trade Practices Act. Some of the claims are for what's known as trademark dilution. You see that on the slide, and that's the unauthorized use of a brand mark, which may dilute or weaken the distinctive quality of a famous trademark. You have actions being brought under the Lanham Act, which is 15 U.S.C. 1051, and related state laws. And again, it's basically false advertising and unfair competition. One thing to just be aware of is that the FDA permits compounding drugs on shortage. The Lanham Act itself, however, does not exempt patent infringement by compounders. So there's somewhat of a conflict between the FDA and the IP law. And that conflict is what creates the incentive for the brand companies to threaten compounders with litigation. The recent litigation is an attempt, if you think about it, to undercut the FDA's authority with intellectual property law. But there is some risk because the FDA has no jurisdiction over patent law and no power to immunize compounding pharmacies from liability for patent infringement. For years, the pharmaceutical manufacturers have been threatening and filing lawsuits against compounding pharmacies, accusing them of infringing on their patents. One of the first cases was minoxidil. There's also other cases involving Avastin, but that was a repackaging case. There's been compounding of Marcu. It's an oral paste for treating equine myeloencephalitis, but none of these recent brand lawsuits against 503A compounders for semaglutide or tirzepatide involve patent infringement. Next slide, please. So the brand pharmaceutical companies, just what this slide is mentioning is they're protected by three forms of intellectual property: patents, trademarks, and trade secrets. The compounding pharmacies can't be held liable for trade secrets because those aren't usually known outside of the manufacturing company. So the two issues for IP that are with semaglutide and tirzepatide are the trademarks and the patents. Patents can be directed to chemical compositions, to formulations, to the device, to the method of using, method of manufacturing. There's something like 18 different patents on semaglutide. The manufacturer claims that it doesn't supply API to outside groups and that it holds the patent on the ingredients. So how can all these manufacturers be manufacturing API? My colleague is going to get into some of this about the cease and desist, I think, on the API and what's been going on with some of the API manufacturers. I'm going to touch briefly on it. So when I said there's no patent lawsuits by Novo against 503A compounders, that's true. But there are 6 patent lawsuits filed by Novo against generic manufacturers like Dr. Reddy's, Sun Pharmaceuticals, and Mylan. Those are the generic companies that filed ANDAs seeking FDA approval to make and sell generic versions of the Ozempic. But those lawsuits are Hatch-Waxman Paragraph 4 patent infringement lawsuits, and they're alleging that the patents in the Orange Book are invalid or they're not going to be infringed by a generic version. All of the cases involve the pen delivery devices, and some of the cases are just to the semaglutide itself. But there are enough patents to provide protection for semaglutide until 2023, according to the Orange Book listed patents. But it's something to keep in mind. Not every patent that's listed in the Orange Book are validly listed. The FTC had notified Novo via a warning letter that may have improperly listed certain patents, such as patents to the delivery device in the Orange Book. And very recently, Novo sent a reply to the FTC stating that it's declining to delist any of its Orange Book patents. So the FTC could sue since they've stated that this could constitute unfair competition, resulting in the delay in generic drug entry. Like I mentioned, none of the 21 lawsuits that Novo has filed against the compounders pertain to patent infringement. Compounding pharmacies don't file Paragraph 4 certification and challenge patents. In fact, there's no examples of patent infringement lawsuits brought by the drug manufacturers against compounding pharmacies that have really reached the trial or substantive judgments by the courts. The cases usually settle, and definitely no court has ever been tasked with deciding whether compounding drugs during a shortage constitutes patent infringement. Next slide, please. So this just talks about what I just mentioned, the different types of intellectual property, trademarks, patents at issue here. Next slide, please. This is just generally a summary of Trademarks 101, function of a trademark, trademark rights, and the value, of a trademark. Next slide, please. So trademark intellectual property issues, the issues revolve around likelihood of confusion, dilution, and tarnishment, especially if the compound is inferior or low quality or counterfeit. Advertisement on a website with wording that makes direct comparisons to Ozempic or Wegovy. Prominent and misleading use of the brand trademark, in some cases direct passing off. Use of the trade dress, and by that I mean something like the same packaging colors. If you look at the Ozempic ads, it's orange lettering. The same type of lettering. If you use the same type of lettering, you start using the jingle, Ozempic, something like that is definitely going to be considered using the, trade dress. Comparing to or same ingredient as, words like that, or implying that the compound is a generic version. Versus fair use, what that means is basically what I've just done here. Talk about the brand name, but in the context of a presentation or some kind of academic use for a lecture or something like that. So always avoid ever mentioning any commercially available product by trade name. The pharmacy can't use the brand trade name to attract customers, generate revenue. And a 503A could also be liable for contributory trademark infringement if they're selling or dispensing to patients of an entity that's making such comparisons. So they themselves are not doing the trademark infringing, but they're selling to some kind of entity, some physician group or something and of course it can't be for office use. It has to be patient specific, right, for 503A. That includes, anything that, makes any comparisons to brand name products by this other group. Any kind of emails that a pharmacy is doing, any kind of Facebook page. One 503A page, it stated, we now have Mounjaro. And what they meant was they're compounded product. They emailed a patient, it's the compounded form, it works just as good. Things like that. Anything that's going to confuse consumers, call them to falsely believe that they're actually purchasing Mounjaro and that the 503A is the source of the Mounjaro. And those are going to be, issues. Next slide, please. So this is why I became a patent attorney. If you look at the great patents that are out there that have, and I certainly could use that pat on the back apparatus. I'm just saying. But and those of you that have children can appreciate the one on the lower left there, I think. Okay, next slide, please. So patent liability, as I mentioned, the fact that the FDA states it will not take enforcement action against pharmacy compounding drugs that are essentially copies that are in shortage. That doesn't mean that a compounder is immune from suit by a patent owner. But why haven't we seen these suits? Why are there 21 lawsuits and none of them are alleging patent infringement? Well, one of the reasons is that the patent infringement lawsuits are much more expensive. They cost, according to a 2022 study, they cost between $2.3 and $4 million on average. They take up to 3-4 years to reach trial. 95 to 97% of the patent infringement lawsuits are settled. Versus your trademark infringement lawsuits, they advance to trial and the quicker, and the cost is around $375,000 to $2 million. But for a drug like drugs like semaglutide and tirzepatide, and pharmaceutical giants like Novo Nordisk and Lilly, this may be a different ball game. So no one can predict what's going to happen. But another reason why the claims of patent infringement for drugs on the shortage and not commercially available, have not been filed, is because the likelihood of prevailing. The brand company's failure to meet the demand for the drug impacts the damages award, which is based on lost profits. So it's hard to show anything here in regard to lost profit damages if the company is not actually able to supply the drug. And another reason is that the FDA guidance on compounding for drugs on the FDA shortage list, it makes no distinction between a patented drug or a non-patented drug. And if Congress had intended to prohibit the compounding of drugs that are covered by a patent but in shortage, the FDA guidance would have stated that. But such a prohibition on compounding, drugs on patent would not be in accordance with the purpose of permitting compounded drugs in short supply, which is, basically to ensure patients can continue to access needed and often essential medications despite supply chain disruptions or issues. Next slide, please. So essentially a copy, as I mentioned, that's detailed further in the 2028 FDA guidance. And initially, Novo had asserted with some cease and desist letters, that there was patent infringement. But, those cease and desist for patent infringement have not necessarily translated to a patent litigation. There is one limitation, however. Not only is, essentially a copy while it's on shortage, once it goes off shortage, medical necessity, but compounders under 503A cannot compound regularly or in inordinate amounts. And so according to recent FDA guidance, there are certain factors that they're going to consider in determining whether a drug is compounded regularly or in inordinate amounts. First thing is that the compounded product amounts to, more than a small number of prescriptions or a small percentage of the compounded products that a compounder prepares. The second factor that they look at is if the compounder routinely substitutes compounded drugs that are essentially copies of the commercially available drug when they receive a prescription. And the third is if the compounder offers pre-printed prescription pads that the prescriber can use. And I'm going to talk about the pre-printed prescriptions in a little bit more depth in another slide. And another factor, the last factor, is that the compounded product is not compounded as needed, but it's compounded on a preset schedule. Next slide, please. So the history of advertising compounded drugs, this is the Supreme Court case, Thompson versus Western States Medical Center. And the Supreme Court decided a long time ago that the compounds can be advertised and any prohibition to do so is an unconstitutional restriction on commercial free speech that violates the First Amendment. So the decision has had an enormous impact on the ability of compounding pharmacies to legally market and advertise, their products. A pharmacy can advertise the compounding service, including the marketing of compounding pharmaceuticals by pharmacies to physicians groups. And more compounding pharmacies are marketing directly to physicians and consumers, but sometimes they're not following, the federal law relating to such marketing practices. And so the goal of marketing is to educate the physicians on the benefits of the compounded prescriptions and ultimately increase physician referrals for compounded prescriptions. But there is such a thing as inducing infringement, inducing patent infringement, inducing trademark infringement. And one of the issues is, that you're inducing the prescribers to infringe on the brand patent. Next slide, please. So another issue with advertising is off-label. And I'll just begin this slide by saying if a pharmacy isn't advertising online, It's difficult for the branded companies to identify, compounding pharmacies, and that lowers greatly the risk of litigation. But the allegations of the semaglutide and tirzepatide cases, they're often supported by screenshots, of the pharmacy's websites. So compounds are not FDA approved, and my colleague Matt is going to go into this more about the allegations of not FDA approved. And the thing is that since they're not FDA approved, they really can't be advertised. And certainly any advertising they can't be advertised for a specific safety and efficacy claim, but even worse would be to advertise them for an off-label claim. So, for example, there's some anecdotal data that semaglutide now can treat depression and bipolar disorder. And so if a pharmacy starts advertising that, that can be problematic. We saw a lot of this regulatory scrutiny for 503A compounding pharmacies with these referrals to the boards of pharmacy when they were compounding ivermectin for COVID-19 and making the off-label claim, for COVID-19. We've seen the cases for topical aripiprazole for pain, ketamine for depression. So, any off-label use. It's not the compounding that's at issue. It's the marketing for a specific off-label use. Next slide, please. So here, false and misleading standard. Again, my colleague's going to talk more about that. I did want to talk about the pre-printed prescription issue. And then basically what this involves is that since the compounded medications are patient-specific, and they're supposed to be customized, pre-printed prescriptions are going to provide documentary evidence showing that the compound is not really patient-specific. And the use of these pre-printed prescriptions, it's a common characteristic of compounding pharmacy fraud investigations. And so, a lot of pharmacies are using these pre-printed prescriptions, but you have to be careful of not running afoul of the state and federal laws and regulations, as well as some of the PBM manuals, although many times these GLP-1 it's mostly cash. But some states, limit the prohibition to controlled substances. Other states prohibit the use of any pre-printed prescription forms. And, we've looked at some of these forms, and often they are missing elements of a prescription that are required under various state laws, such as the prescriber's DEA, the state license number, the prescriber's profession, the MD. And so certain states, they also have, requirements for, whether or not it's a verbal prescription, the route of administration. Sometimes the pre-printed form says injection, but it doesn't say subcutaneous, the strength of the drug, the day supply. If the forms include other non-compounded drugs like ondansetron, dietary supplements, then there's a requirement for a DAW box. So those are, some of the things that we're finding. The form, like certain states require patient freedom of choice. So it's, for example, in Louisiana, freedom of choice law, states must allow the beneficiary to select a pharmacy patient of their choice. And so there would have to be a statement on the pre-printed forms for that. So looking at the rules, certain states, like I say, haven't specified. Other states like Mississippi, Alabama, Illinois have expressly prohibited the use of pre-printed prescriptions. And, to keep that in mind if you're using them, the risk of, shipping or whatever into a state that doesn't allow them is kind of high. Next slide, please. So basically, this is some of the best practices to mitigate the litigation risk with regard to advertising. And the slide isn't specific for, GLP-1 agonists. It's for, advertising any kind of compounds. And, you could take a look at some of the things on the slide with regard to best practices. And with that, I'd like to turn it over to my colleague, Matthew Modafferi, who's going to discuss litigation regarding the GLP-1 agonist.
Thank you, Martha. And hello, everyone. I'm just going to leave this particular slide up here for a moment, to the extent anyone is still reading or taking notes, because it does provide a pretty good summary with respect to advertising for compounds. All right. So moving along to litigation trends, right? So this slide basically divides what we're seeing thus far from the manufacturers into three buckets. The first is the manufacturers have filed lawsuits against your 503A compounding pharmacies to prevent the pharmacies from selling compounded versions of the FDA-approved drugs. Why, right? Why? I think we all can pretty much figure that out. It's relating to competition. We have the only FDA-approved drug. We want all the business. You're taking business away from us. In fact, one judge in one of the Novo cases specifically asked Novo's lawyers, "You're not trying to knock off competitors, are you?" And the response was, "No. These cases are all about patient safety." You can decide that for yourself, but that's the first bucket of what we're seeing. The second bucket are lawsuits that are filed against pharmacies, clinics, wellness spas for false advertising, the trademark infringement, the Lanham Act cases that Martha touched on in her presentation. We're seeing that more and more with respect to both Eli and Novo. And the third bucket, which again Martha touched on, is the cease and desist demands that have been sent to the API manufacturers in an attempt to cut off the API supply. And I'll go into each of these three buckets in a little more detail. Starting with the last, because I think it's the easiest one to deal with, the cease and desist attempts, right? We're aware of a few cease and desist letters that were sent out to API manufacturers, but as far as we know, they have not turned into any active litigation, as far as we know. Why not? There's several reasons, right? Like Martha said there, and it's not on the slide, but it's a good point, is, these cases are expensive, right? If you want to have a patent, you want to bring a patent case, it's quite costly and time consuming. So that could be one factor. The other factor is, jurisdiction. A lot of the API manufacturers are out of this country. Another reason could be that rather than the manufacturers, going after the API manufacturers, they're referring their complaints to the FDA for enforcement. And the last is perhaps it's just a scare tactic to curb the flow of the API ingredient into the country. So these are attempts against the sort of the bigger folk. And what we're seeing is that the manufacturers seem to focus on the smaller kind of customer patient-facing entities, the first two buckets in my initial slide. So moving back to that slide, the first bucket that I talked about are the lawsuits against compounding pharmacies to prevent the sale of compounded semaglutide or tirzepatide. And to date, most of these cases have been successfully defended. And how? Preemption. The Food, Drug, and Cosmetic Act says that the United States has the sole enforcement authority. So private enforcement of that set of laws is barred, right? It's the FDA's purview. There is a carve out for common law claims, such as failure to warn, negligence, and other types of personal injury, meaning, there could be a failure to warn type case for a product, and it's a personal injury case that can survive, even though, it might also violate the Food, Drug, and Cosmetic Act. So in short, the argument is that the manufacturers cannot be the FDA. They're encroaching on the FDA's territory, and those arguments have been, I don't want to say successful across the board because that's not true, but largely successful. So continuing, what we're seeing, because that first round of, you're selling an unapproved product and we have the only FDA approved product, those general allegations have not been successful. So we're seeing a new wave of cases alleging a violation of State Deceptive and Unfair Trade Practices Act. And the allegations are that the compounds are misbranded and adulterated. And what essentially getting deeper, what the manufacturer is saying is, we tested your product, right? And, there are impurities in your product that don't exist in ours. And there could be a safety or immunogenicity issue with respect to your product. It's adulterated. Also, we tested your product and you're saying that, the strength or the potency of your compound is X. Well, based on our test, it's Y, and therefore your product is misbranded. And in support of this new theory, the manufacturers are essentially arguing based on tort law that, in support of their claims, and they're relying on false marketing, advertising cases, food and sunscreen labeling cases, right? Like your sunscreen that you purchase says on the bottle, it says SPF 50, but when we test it, it's really only SPF 20. And that's somehow it's a fraud on the consumer and manufacturing defect cases. So that's kind of the way they're trying to re-argue their case or rebrand, if you want to throw a pun in here. They're rebranding their allegations. But at the end of the day, right, isn't adulteration and misbranding, aren't those core concepts, core elements of the Food, Drug, and Cosmetic Act? So that's, again, some of the arguments that on the defense side, on the 503A compounding pharmacy end, that we're making, right? That, this is the same claim that they've previously brought. It's just dressed up a little differently. It's still preempted by the Food, Drug, and Cosmetic Act, and it's still encroaching on the FDA's territory. And, the purpose of the Food, Drug, and Cosmetic Act is to prohibit the movement in interstate commerce of adulterated and misbranded food, drugs, devices, and cosmetics. Just to take this point in this defense a little further, one judge commented that the FDCA's prohibition on private actions, however, would be thwarted if savvy plaintiffs can label as arising under a state law a claim that in substance seeks to enforce the FDCA. So again, that's the argument that the compounding pharmacies, the defendants in these manufacturer lawsuits are saying. Like, this is just, they're dressing up the pig. That's really what's going on here. And one of the key distinctions to be made from the cases that the manufacturers are relying on to the cases that hold preemption is that the manufacturers are relying on cases brought by consumers or tort victims, where the breach of the duty is owed to the consumer, right? So the state unfair competition laws are not the proper legal vehicle to vindicate the public's interest in health and safety. So another way of saying that is, those cases that allow you to bring there was less SPF in the bottle that I bought than what was on the label, or, I bought a product and I was injured. Those are duties owed to the consumer. The cases that the manufacturers are bringing, there's no duty owed to the manufacturer. Those are pure competition claims. And hopefully, the cases that haven't been successful regarding this new wave of allegations, hopefully we can get the judicial bench to agree with our position here. All right. So the second bucket, right, the remaining of the three buckets, is the lawsuits against pharmacies, clinics, and spas for Lanham Act violations, false advertising, trademark infringement. Contrary to the Unfair Trade Practices Act claims and preemption, where the compounding pharmacies and the defendants have been largely successful, This bucket, the manufacturers have been overwhelmingly successful. And a lot of what we're seeing is, these spas, clinics, and pharmacies, they just didn't know, right? We didn't know we couldn't use the FDA-approved drug name. We didn't know that we couldn't put on our website or our social media that it's the same ingredient as Ozempic or the same ingredient as Mounjaro, the same ingredient as Wegovy, or compounded Wegovy or compounded Ozempic. And as Martha said, you can't advertise for safety and efficacy. And what we're seeing in these cases, because, it's a lot of, I didn't know, right? The defendants, the pharmacies, the clinics and spas have reached early settlements with the manufacturers. And what we're seeing is they have two components. A permanent injunction saying we're not going to do this again. We're not going to mention your product. We're not going to mention that it's, anything regarding safety and efficacy, and some sort of payment, monetary payment. I've heard and encountered differing, points on the payment piece. Is it a percentage of sales? Is it a percentage of profits? That seems to be a little bit of a moving target, but generally the cases have settled for some payment and a permanent injunction. The curious piece of it is that sometimes the manufacturers are delaying an initial settlement until there's some initial discovery. They want to find out some information first before they reach an early settlement. And they want to know, where are you getting your compounded semaglutide from? Where are you getting your compounded tirzepatide from? Who are your API suppliers? Let me see your COA. Let me see your testing. Why? We don't know. Is there another wave of cases that are coming next? We don't know. Are they just, trying to find out as much information as possible, right? Where the competition is coming from, where the API is coming from, who's doing it properly, right? Who's not? One judge in these cases said, when the complaint was initially before him, he said to Novo, just get it off shortage and we wouldn't be here, right? That was his reaction to the lawsuit. And on the other side, to the compounding pharmacy, he said, and just follow the law, right? Follow 503A and you won't be here either, right? So again, that's sort of a very, 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 macro response to how to avoid these lawsuits. But that segues nicely into the first point, right? The judge hit it on the head, is compliance with Section 503A. I think Martha went through a lot of this, but, you need valid prescriptions for individualized patients that are medically necessary. Can't be for office use. If you're using bulk ingredients, they have to have a USPF NF monograph, or components of an FDA-approved drug, or appear on an FDA-approved list. Don't use the sodium API for semaglutide base only. Make sure you vet your API manufacturers, check your COAs. Like Martha said, you really need to know what to look for, or run it by a lawyer, the healthcare lawyer, a pharmacy lawyer, to take a look at the certificate of analysis. The other thing is test, right? This new wave of lawsuits is, we've tested your product and we found them to be adulterated or misbranded based on, mislabeling and potency, or, their finding of impurities. What you can do is conduct third-party testing, right? Make sure that your products are, potent, that they, what you're putting on the label is accurate, that they, are passing the whatever test, I think some states have different compounding rules and how often you have to test, whether you have to test for, ordinarily you don't have to test for every lot. But the more testing, the better. And again, just with respect to the advertising and use of the trademark names, just don't use the product name. If you're going to advertise, if you're going to talk about your product, refer to it as compounded semaglutide, compounded tirzepatide. And when in doubt, it's always a good idea to run it by a healthcare lawyer. One final bucket is what we're seeing on the criminal side, right? We talked about cease and desist and some civil lawsuits brought by the manufacturers, but what's going on with the FDA and DOJ? Generally, this government enforcement takes time, and the trends sort of lag behind a bit. And usually the sort of genesis of the enforcement stems from an adverse event of patient harm. So Martha had mentioned that the end of last year there was some counterfeit product that came into the United States. One or more patients were harmed. Boom, that started, or that was the genesis for an FDA DOJ investigation into criminal investigation. And again, as set forth here, they seem to be focused on counterfeit products, counterfeit needles, whether the product is not for use in the US, it might be, the European version. We're not aware of any federal criminal enforcement for compounded semaglutide or compounded tirzepatide. And again, the government seems more focused on preventing, the counterfeit product or not for use in the US product from coming into the country. All right. So lawsuits from patients, right? The manufacturers are not the only ones being on the offensive, right? They are now dealing with lawsuits against patients, right? There is a multi-district litigation, 75, I think, different cases brought against the manufacturers for failure to warn about gastroparesis. This is just a fairly new phenomenon, but I just want to point it out that the manufacturers are on both sides of the V here. Again, with whether a patient may have a lawsuit against you, compounding pharmacy, again, the testing and vetting of the API are critical. You can have an adverse event, right? If there's a lapse in your procedures and policies, could result in a personal injury matter. So that's why, having policies and procedures, testing and vetting are really important. I won't go into the adverse events reporting page that's public on the FDA's website. But just sort of a final note is, spending time and resources to properly compound at the beginning and having lawyers and running your questions by them and, knowing what you can and cannot say on a website or social media will save time and resources in the long run. So with that, I kind of zipped through it, given the shortage of time because we're running close to the end. But here, here's our Frier Levitt website, our LinkedIn, our Twitter, my information and Martha's information. And, we want to thank you for joining us today. I think we may have time for one or two questions, but, we hope you found the discussion insightful and valuable. If you have any questions or need any additional information, please contact us. We're here for your help and support in navigating these difficult issues. So I don't know if somebody has access. Yeah, Martha.
I have this three questions. I can take the first one, and then I think the second one is yours, Matt. It says pre-printed prescriptions. Is that an issue even if the product is on the shortage list? And with regard to the rules for the pre-printed prescriptions, it doesn't matter if it's on the shortage list or if it's off the shortage list. The state laws are not that specific. They don't talk about drug specific. The only drugs they some of them do mention are controlled substances. Some of them say absolutely not. You can't have pre-printed prescriptions for controlled substances. just looking at like some of the breakdown of the states, like Arizona, California, and again, this is a fluid list because it could change. Last time I looked, which was a couple of months ago, Arizona, California, Colorado, Delaware, Florida, Idaho, Louisiana, Michigan, Minnesota, Missouri, Montana, Ohio, Rhode Island, South Dakota, Washington, Wisconsin, and Wyoming allow the use of pre-printed prescriptions. They haven't specified that they can't be used. We have some just prohibiting them for controlled substances. You have Connecticut, which might imply that if a non-control is okay. Connecticut, Indiana, Maine, Maryland, New Jersey, New York, Virginia, and West Virginia. You've got Mississippi, Alabama, and Illinois expressly prohibiting them. And then some states, they leave the issue, unaddressed. So, it's like I say, before you engage in that, you want to make sure that it is okay on a state level. The question 2 says, in the slide on lawsuits against compounding, you say that pharmacy can't say same active ingredient in Ozempic. Is that only the 503A facilities that can say this, but the 503B bulk compounders are allowed to say this phrase? Matt, you want to take that, or you want me to take it?
Yeah, I mean, the law doesn't discriminate, right? My answer would be that no, you can't, because what we're seeing, a lot of the lawsuits against the spas and the clinics, they are not compounding, right? They're getting their compounded semaglutide or their compounded tirzepatide from a 503B in a lot of instances. And they, the 503Bs and those entities cannot say, we have, compounded Wegovy or compounded Mounjaro, or the same active ingredient in Mounjaro or Ozempic or Wegovy. The best practice, right, to avoid a lawsuit is, compounded semaglutide, compounded tirzepatide. I don't know if you want to add anything else to that, Martha.
No, that's exactly what I would have said. Same thing. There is a third question. I can read that. It says, I thought the 503A compounding was under the state board of pharmacy jurisdiction. How is the FDA so involved? And the answer is that they collaborate. The FDA closely collaborates, with the state officials, and they share information about compounders who engage in poor practices. They share complaints. If there's an adverse event, that's going to precipitate them sharing information with the state. They share findings on inspection. And, what you see sometimes is they are going to, they invite the states to participate in inspection of compounders. So, the 503A, they're increasingly being inspected by the FDA, and the Board of Pharmacy is often in tow with them. The Board of Pharmacy leaves, but the FDA stays. And when they stay, an inspection by the FDA doesn't take like one day. It's not like a Board of Pharmacy inspection. It can take, a week. And if you do have FDA come to inspect, you want to make sure that you retain legal counsel for that. There's a lot involved with that. And then the other thing is that, in May, the FDA put on their website compounding information for states, and they cited Section 105 of the Drug Quality and Security Act and said, and I quote, FDA may receive submissions from state boards of pharmacy concerning certain actions taken against compounding pharmacies or expressing concerns that a compounding pharmacy may be acting contrary to Section 503A. So there was this MOU that never materialized, but there's still a lot of collaboration there. So we want to thank you for joining us. And like we say, if you have any questions, you can send us an email. Thank you very much.
Thank you.